Did you know there are 7 common ways to hold title on your home, but which one should you use? More importantly, were you aware that how you hold title can have significant legal and tax implications that could cost you thousands of dollars?
Get out!
I know, it's hard to believe, but the way you hold title can have significant tax consequences. Now, I will cover 6 of the 7 common options of holding title in California. While one of the most commonly used forms is joint tenancy, but many legal experts point out that this may be a poor and costly choice. So we'll take a look at why that is, plus common mistakes, and by the end of the video, we'll cover the big tax issue that you can avoid costing you thousands of dollars. Hi, I'm Harold Powell. I'm a local Ventura realtor helping people buy and sell in Ventura and the surrounding communities. Now, I'm here to talk to you about holding title on your home that you currently own or potentially buying. Now, if you're getting ready to sell and buy, I even suggest watching my video on selling and buying at the same time. Otherwise, once you are in escrow is going to ask you, how do you want to hold title? And the 7 common options in California are, starting with number 1, sole ownership, number 2, tenants in common, number 3, joint tenancy, number 4, community property, number 5, community property with right of survivorship, number 6, living trust, and number 7, an LLC or corporation. Today we will focus on 6 of the first options. Number 7, the LLC corporation option, is often used for rental or investment properties, which we won't really go into today. Now, as I said earlier, how you hold title has profound legal and tax implications. So I recommend you seek legal and tax advice since I'm not a legal or tax expert. Now, to save you from having to write all this down, I have a downloadable version that will break down the differences of the different ways to hold title. Additionally, I'll also include some information on joint tenancy versus community property on a tax example. All right, so let's begin with the easiest one, which is sole ownership. So if you are a single person buying a house to live in, then your option would probably be sole ownership unless you have a trust. Now, if you have a trust, then you can put it in your trust right away. Otherwise, you can go ahead and close as a sole ownership and transfer it later when you have the trust ready. Number 2 is tenants in common. Now, tenants in common is used when there are more than one owner and you're not married. The ownership interest can be divided into any number of equal or unequal interests, and upon death of a co-owner, his or her interest is passed by a will or trust. There's no right of survivorship. If you have a trust, you will close escrow with tenants in common, then you can transfer your portion to a living trust. So, for example, if you're buying a house with a fellow investor, brother-in-law, or uncle for that matter, then you want to hold title as tenants in common. And let's say, for example, if your uncle put 70% of the money into the property, you put 30% in at a 70-30 share. When your uncle passed away, his share would go to his children. Number 3, joint tenancy. Joint tenancy actually happens to be one of the most popular ways of holding title, but experts argue for several good reasons that it may not be the best way. So when you hold title with joint tenancy, it creates what we call equal interest, and upon death of a co-owner, his or her interest is conveyed to the survivor. The interest in joint tenancy cannot be willed, so what's the problem? Well, let's take a look at a few examples that can create legal problems and potential mistakes. And in this example, under joint tenancy, you die, your share automatically goes to your business partner by definition of joint tenancy. The last one surviving takes the property and nothing would go to your heirs or children. That would be a bummer. Example 2, let's say, for example, your mom, who's a widow with children, remarries to a guy named Ryan. Now, your mom and Ryan each put up $1 million towards the house they buy under joint tenancy, all cash for $2 million. Your mom passes away a year later, and by definition of joint tenancy, Ryan gets the property in its entirety, since your mom cannot will it or even pass it on through a trust because title is held under joint tenancy. Another mistaken use of joint tenancy is when a well-intentioned widowed parent thinks that adding their son or daughter to the grant deed will make it easier for them to take over property upon passing. Well, the first problem that can actually cause is a property tax reassessment problem. Doing this could likely trigger a reassessment of 1/2 of your property tax basis, especially if your son or daughter is actually not even living in the property. So this could result in significantly higher property taxes. The other potential problem is when you add your son or daughter to your house as a joint tenant, and let's say they have an IRS or credit problem. Well, if they have an IRS problem and they don't pay the taxes, then their tax problem just became your tax problem. And if you ever wanted to sell and they still have the IRS lien, when you sell, you'll have to pay that off in its entirety at the close of escrow. On the credit side, if they have to file bankruptcy, then the credit company can actually file a lien on the property as well. And lastly, if you ever wanted to sell the property, they would have to agree to sell it. And if they don't want to sell it, then you can't. On the other hand, a trust can solve this issue. It allows the parent to convey the property to the son or daughter without any of the potential problems mentioned. Now, if you are curious about the tax issue of an inherited property, I suggest watching my video on taxes on inherited property. Now, let's look at the potential tax problem when we compare joint tenancy versus community property. Now, let's first look at joint tenancy tax example. First, let's use this example. Say a husband and wife bought a property 20 years ago for $200,000. The husband passes away and the home value at the time of death is $2 million. The wife decides the house is just too big and ends up selling it for, again, $2 million. So what is the capital gain or profit on this house? Well, in this example, the husband passed away, so his half gets stepped up basis to $1 million. The wife is still alive. They bought the house for $200,000, so her half, her cost basis is $100,000. So when calculating the capital gain, we take the $2 million minus 1.1, which came from the husband's stepped up basis, plus the wife's $100,000 basis. So the result is $900,000 of capital gain dollars. Now, side note is the wife would be able to use the principal residence rule, which would allow a single person to exclude $250,000 of capital gain, which would drop the capital gain amount to about $650,000, which is still a sizable number of capital gain. Now, the good news is there is a way to avoid paying all of the capital gain in this example. Let's compare this to community property as a married couple. Now, as a married couple, you can hold title on your home as community property, and there's actually two types of community property. There's community property and community property with right of survivorship. So the difference is in community property, a spouse can will or his or her interest. Now, this could be because both spouses remarried and want to will their interest to their kids, right? Whereas a community property with right of survivorship, the surviving spouse owns the property in its entirety. So if you want your husband or wife to have the property when you pass, then you should probably choose community property with right of survivorship. Now, let's compare this with the same tax example that we discussed with the $900,000 capital gains under joint tenancy. So, in community property, when a spouse passes away, you get a double stepped up basis. So, using the same example of the home that was purchased for $200,000 and the husband passes away and the value of the house at the time of death is $2 million, the wife again decides to sell the home for $2 million. The husband's half gets stepped up to $1 million. And the wife also gets a stepped up basis to $1 million as well. So there's zero capital gains on a $2 million sale. Amazing. Now, even if the wife chooses to sell years later, let's say for $2.5 million, she would be able to use the principal residence rule exclusion of $250,000 for a sole owner on top of the $2 million stepped up basis and have up to $2,250,000 tax free. So, for tax reasons alone, community property has a huge advantage over joint tenancy. Now, you may be wondering if I should even bother putting the property in the if we hold title as community property, right? Well, the reason is when both spouses pass away and there is no trust, then the property has to go through probate. And the probate not only costs about 5% of the sale price of the home, it can also take 9 to 10 months for probate to settle, assuming no one in the family objects. The trust cost will only cost about $2,500 to $3,000 for a typical trust versus something that goes through probate. Let's say it's at $2 million, could be over $100,000 in attorney fees alone. So at some point, you'll want to see an estate planning attorney who can set up your trust and put everything under community property. It should be noted that having a will does not avoid probate, but trust actually does. So if you are interested, I can give you a couple names of local estate planning attorneys that can help you set up a trust. Now, if you found this helpful and you want to be notified of upcoming content, then hit the like, subscribe, and bell icon. Thanks.